Hello there everybody, Bill O'Leary here coming to you in this video, and what I'm going to talk about is the Florida probate process. What is that all about? So quick introduction, again, my name is Bill O'Leary. I'm an attorney. I focus on elder law, estate planning, and probate, and my firm here in Jacksonville, Florida is Legacy Planning Law Group. So let's jump right in. Florida probate process. What is that all about? What does that look like? Well, it's a legal process. It's a legal process whereby your estate, and by the way, everybody has an estate, big or small, is going to be handled, yes, by somebody on a day-to-day basis, but with the oversight of the court system, a probate judge. So you can probably break down probate into three stages, three big stages. One is the opening of the estate. And so that involves making some initial court filings, filing a petition or two, and asking somebody on behalf of the estate, asking the court to appoint them as the executor of the estate. We now call that person a personal representative. And to have the judge issue the all-important, what are called letters of administration. You might hear the term, oh, I need letters. Well, it's not a letter you write to a family member. It's a court type form or document called a letter of administration. That gives you all the authorization you need to serve as a personal representative on behalf of the estate. So that's really the first big stage, opening the estate. Second is administering the estate. So first and foremost, the responsibility of the personal representative, we'll call it the PR for short, is to identify, organize, what's called marshal the assets, figure out where they are. Number one. Number two, notify the heirs, the beneficiaries, of the fact that the estate has been opened. And three, identify creditors and see to it that they get paid, at least the valid creditors get paid. So that's the second big stage, is administering the estate. And then third is closing the estate. And that typically involves, again, another court filing another petition to close the estate, and asking the judge to enter a court order of discharge, because understand, during the pendency of the estate, the executor, the PR, has certain personal liability if they don't do things right. You want to relieve yourself as the PR of that liability to get discharged from it. So those are the big three stages: opening, administering, and closing. Now I want to try to get a little bit more granular and drill down the steps, and I've come up with 9 steps of the Florida probate process. Number one, talk to a lawyer, hire a lawyer. And the lawyer is going to ask you, okay, good, do you have a death certificate? We need that to get started. Was there a will? If yes, sort of we go down one path of the probate process. Oh, if there was no will, we go down another path, okay? We have to identify the path first. The lawyer will help you do that, number one. Step two is opening the estate. Again, is filing that petition. To get appointed, again, those letters of administration, notify the heirs of their beneficiaries. That gets things started. 3, identifying the creditors. There are 3 different groupings of creditors. 1, creditors that you know about, so you know about the unpaid ambulance bill. 2, a creditor that may not be known but is reasonably ascertainable. What does that mean? Well, with a little bit of due diligence, you as the PR could figure it out. Just go through the deceased records and you could have figured it out. Those 2 groups together are entitled to a certain special kind of notice that you have to give them, an actual notice of the pendency of the estate, and give them an opportunity to come forward with their claim. They have 30 days to come forward or forever hold their peace. And then the third big grouping are unknown creditors and those that are not reasonably ascertainable. There you have to publish in a newspaper for 2 consecutive weeks and then allow 90 days to run. And so if they don't come forward with a claim, they forever hold their peace. 4 is conduct an inventory of the assets. So identifying all the assets, where are they? As well as valuing the assets and attaching a value as of the date of death. So that's step 4, conducting an inventory of the assets. Step 5 is now we come to the end of that creditor period. And so again, identifying those creditors and to pay creditor claims, either cash that's in the estate. If there's not enough cash, you may have to liquidate an illiquid asset. But understand that you don't have to necessarily pay every creditor claim. Only those that are valid. So you have to evaluate them. So an invalid claim may be, something that the deceased did not owe. Or even if the deceased did owe, but the creditor filed it too late, and that happens all the time. The creditor may send in a creditor claim that is too late, and then we object to it, and they will not get paid on the claim. So closing the creditor period. Step 5, or actually step 6, is paying taxes. That's often sort of overlooked. The deceased has a final income tax return for that year. There may be an income tax return that will be has to be filed for the estate, and there may be some estate tax issues. So those are taxes, step 6. Step 7, in accounting, a final accounting. Put it together so to show the beneficiaries and the court how the money was spent. So the value of the assets, how the assets were spent, to the extent those assets may be generated income during the period of the estate, any creditor claims, and put together and file that accounting. By the way, in a lot of estates where the beneficiaries are all on the same page, they get along, then they can what's called waive the accounting. They file a waiver of the accounting so the PR doesn't have to put it together. Step 8 is to make final distributions. Those distributions can be made just as an outright distribution, get a check cut. It could stay in a continuing trust depending on if, let's say, there was a will that provided for an ongoing trust. Or if it's going to a minor, then you may have to open up a guardianship for the minor. So that's step 8, final distributions. Step 9, closing the estate, getting that all-important order of discharge. So you as the PR no longer have personal responsibility. So again, those are the 9 steps I've been able to come up with as to the Florida probate process. If you'd like to know a little bit more about Florida probate and how we can help, we'd love to talk to you. So, as we do in all these videos, invite you to go ahead and schedule a free 15-minute phone call to our discovery call. Click on the link that's in this video. Boom, takes you to our booking calendar. Pick a time that works for you. We'll jump on the call. Remember, like and share, and go ahead and click on the notification button so that you'll get notices of new video content that we put up. So, Bill O'Leary signing off for now. Go make it a great day and a better world.